Harvey L.J., Chief Judge presiding. All persons having business before the court draw near, give attention, you will be heard. May God save the United States of America, the state of Florida, and this honorable court. Please be seated.
Good morning. Welcome to Daytona. Welcome to the 5th District Court of Appeal. As you just heard, I'm Harvey J. I have the privilege and honor of being Chief Judge of this court, and I am joined here by two of my finest colleagues, Judge Eisnagel to my right, longtime 5th District Judge, and to my left, longtime trial judge, and now 5th District Judge, Judge Boatwright. A couple of quick things. We've got two cases on the docket today, but if those in the audience and the advocates as well would be kind enough to turn off any electronic devices that may have a noise mechanism. There's nothing worse than having a phone or iPad or laptop going off during an OA. The second thing, for the benefit of the panel, you guys are here for a reason, and that reason is we have some questions, and so it would be greatly appreciated if you would listen carefully to our questions as well as being responsive to those questions. Otherwise, there's no reason for an oral argument. I know the good advocates here realize that. So the first case on the OA docket today is Beachway Restaurants versus Coquina Beach Holdings, case number 250310. If the lawyers want to come forward for that case. Mr. George, are you ready to proceed?
I'm ready, Your Honor.
All right, you may come to the podium, and before you start, if you would be kind enough to let us know if you would like any time for rebuttal.
Yes, Your Honor. I could reserve 3 minutes.
3 minutes. When you're ready, please proceed.
May it please the court. Again, my name is Robert George, and I'm here today on behalf of my clients, the appellants in this matter, Beachway Restaurants, LLC, and James Wigg. Before I get started with the merits of my argument, I thought it might be beneficial for the court to address the factual and procedural history of this case and address any questions the court might have regarding that. Again, this is a case that is derived from my client's purchase and operation of a beachfront restaurant in St. Johns County called South Beach Grill, and then the subsequent forced removal from those commercial premises by the appellees. Specifically, my clients purchased the restaurant assets in 2018. Early 2018. At the time, it was been operated for 20 plus years by the prior operator. It had always been a traditionally seasonal restaurant, but a very profitable restaurant. The purchase included a sublease of the very favorable...
Let me interrupt you if I may, Mr. George. There is a lot of talk in the briefs about evidence that is uncontradicted, unrebutted, and that's a large part of the argument that the court couldn't do anything other than follow that unrebutted, uncontradicted evidence. But let me ask you this. You would agree, as the finder of fact, the court had the right to evaluate for reliability, believability, all the evidence, including uncontradicted evidence.
Yes, Your Honor, I would agree with that. However, there are standards to that discretion as to, again, as the what we addressed in our briefs, even if it's a factual finding, it has to be supported by competent, substantial evidence, such that a reasonable person could view that as a basis for the decision of the court. And that's where we believe there was some undisputed evidence, but we believe there was some disputed evidence and some findings by the trial court that just were not supported by competent, substantial evidence.
Well, let me ask you about so-called, air quotes, undisputed evidence. Even that could be rejected by the trial court if the court found it not to be reliable, correct?
It could, again, subject to the same standard. And so, like an example, the court found that my client caused $593,000 of damage to the property when that was not supported by any of the evidence, including plaintiff or appellee's own expert, who specifically stated, I didn't inspect the property until 2.5 years later. My opinion was based as to the cost that would be needed to reopen the restaurant. Many of the costs.
The amount that was testified to, the $539,000, right? Is that
$593,000.
$593? That was, perhaps the amount wasn't competent, but in the brief, you argue that there was just no evidence that your, Mr. Wigg, right?
Yes, Your Honor.
Used a chain to break anything other than windows. Your initial brief argues that he didn't destroy anything else. You said there's no competent substantial evidence. I'm not sure that's true. Yeah, you sort of argue that just because there were no videos of the event, the alleged event, being entered into evidence, I'm not sure that necessarily means that Ms. Kluger's testimony that it happened, it might have been inadmissible, but if the evidence came in, right?
That is correct, Your Honor. So Ms. Kluger did testify as to quite a few elements of the court's finding. Again, and we believe this is where you would need to
Why
look.
couldn't the court, I guess the question is perhaps the number, let's assume for a moment that the number's not justified, the 593. There was, but the underlying testimony from Ms. Kluger was that he destroyed, what did she say? She started at 6 and went to 3? Was that the testimony?
6 to 3. I'm sorry, I don't understand.
As far as time goes? Hours.
Oh, hours of.
He was destroying things for hours. Wasn't that her testimony, or am I
Was her testimony that there was video footage?
Right.
That when asked about the video footage.
And your argument is that despite her testimony, they didn't introduce those videos.
Well,
So-
they weren't produced. They were requested in discovery. They weren't produced. An example, we would argue.
Was there an
that-
objection to her testimony that it happened?
Yes, Your Honor.
Okay.
We specifically said this shows the credibility of Ms. Kluger, along with the testimony regarding abandonment, which I believe is the more
But
critical issue.
did you object below to admissibility of that testimony?
We argued as to the credibility, Your Honor. We objected to the.
But credibility and admissibility are two very different things.
I would agree, Your Honor.
Right. So did you object to the admissibility of her testimony?
Your Honor, I will be honest, standing right here, I specifically do not remember if I asserted that objection.
I mean, wouldn't that be important? If the evidence came in because there was no objection, then why couldn't the court rely on it? Don't you have to lodge an objection in order to now raise it on appeal?
Again, I think the court can rely upon it, but the court's decision is still judged by that standard of, is it supported by competent and substantial evidence, such that a reasonable person would view that it is appropriate to reach that determination.
Is her testimony not enough?
Your Honor, in this case, I don't believe it is. I don't believe, especially looking at abandonment. Again, she testified that she conducted 4 spot inspections on the property. Now, the objective third-party evidence of the credit card processing company demonstrated that on 3 of those 4 dates, there was business going on in the restaurant.
Relatively small amounts, right?
Well, a total of 300 tickets for those 3 days.
Yeah. What were the amounts? 2,400.
You're
Here, November. I think on November 2nd, it was $2,200, November 3rd, $2,400, November 10th, $55. That doesn't sound like a robust restaurant operation.
A robust operation is not the standard, Your Honor. It's whether he
Yeah.
was there in business. He could be doing $1
I don't know.
business.
I'm not sure because didn't you have to prove damages? I mean, if you could show one ticket a day, then you could certainly make the argument that the property itself wasn't abandoned. But don't you still have to show actual damages? The nominal damages issue aside, we can talk about that. Perhaps that's a different issue, but other than not potentially nominal damages, don't you have to actually show that there were damages, for instance, for tortious interference?
We do, Your Honor. And again, that was done through the testimony of the experts, Dr. Lowe from Appleese.
But why couldn't the trial judge reject that based on this evidence that at best there was very limited operations in November, right? Why does the judge have to believe that the expert when the expert says the value of the business was nearly $3 million?
Well, again, it does go to, the trial court could believe that, but that is not the standard. The standard is whether that belief was supported by competent and substantial evidence, which would allow a reasonable person to believe that that evidence supported that determination. And again, what
I thought we were just talking about your expert's testimony, and I was saying, why couldn't the trial court reject your expert's testimony on value based on this, what appears to be undisputed evidence that at best there were very, very marginal operations on these days?
I don't think that's what the trial court did, though, Your Honor. I think the trial court said the restaurant had been abandoned, and specifically used the word abandoned.
Wasn't he really saying, though, that the business operations has ceased? I saw your argument about abandonment and almost like a legal abandonment, but it appeared to me what he was really saying was that the business operations had ceased at that point, which to me, is that different than the legal argument you're making about abandonment with a legal, in accordance with a legal eviction?
Well, he found abandonment. He stated abandonment. There is a term of art used for abandonment, and
He also used that in relation to ceasing business operations, correct?
Correct, but again, there were business operations going on. 3 of the days, regardless of whether we're looking at small numbers of ticket items, again, this is ticket items for one of the slowest periods of the year for that restaurant, as testified by the prior owner and Mr. Wigg during a pandemic.
Was there testimony to compare these numbers to prior years in November? In other words, was
Yes, Your Honor.
$55 in transactions in a day, is that normal in November?
So, Your Honor, the numbers did show that 2020 obviously were lower than 2018 and 2019, pre-pandemic.
How much lower?
Probably about $1 million less in gross sales. I think for 2020.
I mean, just in November. I mean, what are we, in one day in November, I mean, that's the problem when the trial judge would look at that evidence and say, well, gee, okay, so there were some tickets on November whatever, but it was $55.
Again, I don't think you can look at strictly, that's the problem, the inherent problem with how Dr. Lowe valued it. He looked at a select number of months during the slow parts of the year. I think
I have other problems with how Dr. Lowe evaluated things, but we'll get to that in a minute, right? I think what we were talking about here was you said, hey, well, look, November was one of the slowest months of the year. I get it. So what about November in 2019? What about November in 2018? Were there days when there was only $55 in transactions?
There was no evidence presented as to the day by day, but there was presented as to the year, and I believe month by month. And November, September, October, November, and December were the slow parts of the year. Those were traditionally the slowest parts of the year. It started picking back up and was very busy during the spring. The February, March, April time period was usually the business, and then remained busy during the summer. Again, I used an example in our motion for new trial, where it's almost like going to Chicago in January and February and thinking it's cold in Chicago 12 months a year. You know, Chicago has a very different, distinct and wide range of temperatures. You can't look at a business or a city's temperature for just a little period of time and say, hey, listen, the business is going under.
I mean,
Again,
unless it's come to a screeching halt.
but it hadn't come to a screeching halt. It was still
$5
operating.
in a day.
It still had, but still, there are businesses around here, around Florida, especially during a pandemic, they were still open. Many businesses this temporarily closed. This
Is
was
this
a business
past the
that's still.
pandemic, though? I mean, we'd gone outside the pandemic at this point, or had we not?
I mean, restaurants were allowed to be open, but it was still in a pandemic. I don't think many courtrooms were.
What about the fact that the judge found that the rent was stopped being paid through June? I know you disagree with that, but what about the fact, if that's the case, that he made that finding based on the testimony, would that not show that the business had ceased?
I mean, there was disagreement in that, and the problem we have with that is that the court had previously found the rent had been paid. In its summary judgment that it granted, it stated, from May of 2019 through November of 2020, plaintiff directed Beachway to make direct rent payments to plaintiff. Beachway made the direct rent payments to plaintiff, and plaintiff accepted each and every one of those rent payments.
But, Mr. George, and I know you know this, the court can always revisit interlocutory rulings. This was an interlocutory ruling. The judge had every right under the law to revisit that, correct?
Two issues with respect to, I agree, Your Honor, but there are two issues with respect to that. There was also a stipulation made by the appellees, that same language, that they agreed to that. And as a stipulation, they are bound by that stipulation. Second, a court can readdress issues, but they're still subject to due process. And, Your Honor, we were not even aware that this would be an issue. The court had previously specifically stated it. There had been a previous stipulation by the appellees on this issue. If we were aware that, we would have been prepared. That this should never have been addressed by the court. It wasn't relevant to any affirmative defense or claim that was being raised. There was, if it was, we could have brought in, and if you look at the motion for a new trial, we did include an affidavit from Ted McLemore who said, I would routinely give the checks to Robert Crabtree, who would never cash the checks. I mean, this was not something that was uncommon. This was something that was very common in the history of how the appellees had operated the restaurant, served as his landlord. Not operated the restaurant, but served as the landlord for the restaurant.
Let's assume for a moment that we agree with you that the rent payment issue, that the trial court missed it on that. So assume for a moment that we agree with you there. Why isn't there enough, assuming we also think that there was plenty of evidence for the trial court to conclude that the operations themselves, even though the property hadn't been abandoned, the operations themselves had dwindled to what would be essentially a halt. Why is that not enough? Like, why, in other words, why do we need to reverse just based on the rent payment issue?
Because if you look only to a restaurant that's struggling during its slow part of the year, during a pandemic, that does not give the right for a landlord to come in and retake possession of a commercial lease property without an order from the court. That is the law. If
That is correct.
If
And-
that was the law, that would set an incredibly dangerous precedent.
That is correct. But other than nominal damages, and that, I mean, you raised that in your brief. I think it's a fair argument. We can get into that if you'd like. But other than not the issue of nominal damages, you still have to prove, I think, you have to prove your damages, correct?
Still would have to prove your damage.
And it's difficult to do that. Or how do we sort of reverse the trial court on a damages type issue when there's at least some evidence that by November there were very, very minor operations, if at all, at the restaurant?
Again, that's like finding in Chicago, it is 15 degrees all year long.
I'm not sure it is, because we you haven't there is no, well, tell me if there is. Is there evidence to compare the $55 for the day in November? I can't remember which day it was, but whatever amount, right? There's the 2,100 day, and can you compare that and say, well, no, that's not normal. That is normal for November. Maybe it is. Where is that in the record?
There was testimony by Mr. McLemore and Mr. Wigg as to the seasonality of the business and how.
No, I understand that, but the amounts, right? Like seasonality is one thing, but is it normal to have a day where you only make $55 in transactions in November? Is that normal?
Again,
Does that happen every November?
I don't think there was any issue raised about as a specific day, but we did raise the fact that where the court said there was an abandonment, we showed that there was operation going on, and again, over 300 tickets for 3 days in a slow month during a pandemic. And again, just because it's slow does not give the landlord the right to re-enter a premises and forcibly remove a tenant. This might be
So you're
the
into your
first-
rebuttal time, just so you know.
Okay. This might be the first and only case I've ever seen where, again, abandonment is a peaceful surrender. And it requires intent and action in, furtherance of that intent by the tenant. That was not what happened here. This was a forceful removal and where they prevented his reentry. This might be the only case I've ever seen in Florida where a court found that there was an abandoned commercial property where there was a forced removal, a forced prevention from reentering the property. That just provides a horrible precedent that says you, the tenant, to avoid not being forcibly removed from your business, you have to use the same or greater force than the landlord who's trying to get you out of the property.
I'm not
And
sure that's what that decision would say if we reach that decision, counsel.
It
But
would
I understand. I think that in rebuttal, you might think about the difference between, yes, the eviction may have been wrong, but what about you still have to prove damages?
Mr. George, there was a lot of colloquy there. I'll give you 2 more minutes. That'll give you 2:41 on rebuttal.
Okay.
We'll also give it to the appellees. Doesn't mean you have to use it, Mr. Winter, but you have 22 minutes.
right.
Thank you, Mr. George.
Good morning, if I may proceed.
Please proceed.
My name is Alan Winter. I am the attorney for the appellees in this case, the principal of the Winter Law Firm. I have been with this case from the beginning. Now, the reason why I say that is, and there's been several very good lawyers on the other side, but by my count, since the very beginning in this case, there were 8 either lawyers or law firms that represented Mr. Wigg in this case.
How is that relevant, counsel?
It's relevant because Mr. Wigg's credibility is being brought into question by Judge Maltz. He was the finder of fact in this case.
Okay, I don't think the number of lawyers probably gets you there, but go ahead.
It may not, Your Honor, but I do know that at least one of them had to remove himself because of irreconcilable differences.
Again, counsel, I'm not terribly convinced with this line of argument, but you can proceed if you'd like.
No, that's the argument, and I thank you very much. All the parties in this case agreed that Judge Maltz would be the finder of fact. He would be the trial judge. This was not a judge by jury, or a trial by jury. This was Judge Maltz being placed in that position. It's a high burden. We place on our trial judges here in Florida a heavy burden. They have to run the trial.
Was the eviction wrongful? As a matter of law,
As a matter
was
of
the
law-
eviction wrongful?
No, I would say no, and I'll say this about that.
The judge found it was unlawful, though,
He did,
correct?
Your Honor, and I still disagree with that.
Well, I didn't ask if you agreed with it. As a matter of law,
As a
what is
ma-
law of the case? Was it wrongful or not?
Yes, as far Judge Maltz found it to be wrongful.
And you
He
haven't
did.
challenged that?
Excuse me?
You haven't challenged that ruling?
No,
No. So the eviction was wrongful, correct?
correct.
Okay. I mean, you didn't file notice of appeal. So you're not challenging that ruling by the trial judge. The trial judge said it was wrongful.
Correct,
Correct. Okay.
correct.
So that if subsequently he makes a finding of abandonment as to the appellant's argument, would that be internally inconsistent?
I don't believe so.
And why not?
Because Mr. Wigg, in this case, the one who destroyed the restaurant, if you're going to destroy the restaurant, you're going to basically abandon a restaurant, even if it's not profitable. By destroying the restaurant as he did on video.
That was after the wrongful eviction, correct?
Yes, yes, it was, Judge.
Right.
Yes, it
So,
was.
but as of the day of the wrongful eviction, I'm just not sure how strong your argument is when you're basing it on stuff that happens after the wrongful eviction has already occurred.
I understand, Your Honor. The history in this case is that the original lessee, Mr. McLemore, who basically subleased the restaurant to Mr. Wigg and did so surreptitiously, that's why the rent checks issue arose, that Mr. McLemore continued to pay the rent checks when it was Mr. Wigg who should have been paying them. And if that had happened, my clients would have been placed on notice appropriately that actually Mr. Wigg was the one who was now saying that he was in control of the restaurant. It was his restaurant.
Your clients knew that by November 19th, according to my record.
Yes, that's true.
Okay, all right.
There was a period of time.
They weren't under some misunderstanding that Mr. Wigg was not supposed to be there.
No, the only misunderstanding was that they didn't agree with him being there.
Well, didn't the trial judge rule that the sublease was appropriate?
Yes, he did.
Okay. Did you
Yes.
challenge that?
No, we did not.
All right.
The only other challenge in this case was the punitive damage claim, which this court has ruled PCA in our favor. So that was the only other second appeal. That was the first appeal in this case. This is the second appeal in this case. We had since, as part of the case, settled by mediation with the original plaintiff in this case. So
I guess I'm just saying that, your argument, you're talking about whether or not the sublease was appropriate, whether or not your client had notice of it. But it seems like the important date here is November of 2020. And by then, I don't understand. First of all, the trial judge already ruled that the sublease was appropriate. You didn't challenge that. Either way, your clients knew about the sublease well before November of 2020. So why is that a relevant line of argument for you? I just don't understand how that's persuasive.
I would agree with you in that regard, that the sublease, because we didn't appeal it, makes it.
It's not the case. You didn't challenge it, right? So,
Correct, Your Honor.
Okay, so we have to assume that there was no issue with the sublease, that was fine. Because you didn't challenge it, right?
Yes.
Okay.
The reason why I'm smiling is because my clients clearly had difference of opinions about that. But did they want to appeal? No, they did not want to appeal. They wanted to see a vibrant restaurant continue somewhere, somehow.
It's clear that Mr. Wigg had not, on our record, the undisputed evidence seems to reflect that Mr. Wigg had not, as of November 19th, 2020, had not abandoned the property itself. You agree with that?
No, I don't.
Okay. How? He was there when the wrongful eviction occurred.
He was there, but the restaurant itself, the employees, that's why he got in trouble with the PPP loans, is because the restaurant itself, the food license.
But he didn't abandon. It seems to me there's a difference between abandoning the property itself and abandoning operations of the restaurant. Can you see the difference between those two? Okay.
Yes.
So it seems like there is a pretty strong argument that there's some evidence that the operations of the restaurant were effectively abandoned, but the property itself, it seems, was not. I mean, it seems like all of the evidence suggests that he did not abandon the actual property itself. He was there on the day that the wrongful eviction occurred. There were at least some sales, or at least evidence. There was evidence of some sales anyway, right?
Yes, there was. Very, very minimal, but yes, there were some sales.
Okay, so perhaps perhaps the property itself hadn't been abandoned. You know, if he was there all the time, it would be hard to say the property itself was abandoned. But what about the operations of the restaurant?
I'm trying to remember what the testimony at trial was on that case, but I believe Judge Maltz indicated that as of that period of time, the restaurant was, quote unquote, being abandoned because it was losing money, it was not profitable, it was losing its licenses for food, and...
Well, the license was renewed according to Mr. Wigg, but...
Well...
But Ms. Kluger went into the restaurant, four days in November and testified that every time she went in, there were no employees, there were no customers, there were no operations at all. And the initial brief doesn't take issue with that, doesn't say that she didn't testify that or say that it was untrue, right?
Yes. I think one of the most, on page 5 of the final judgment by Judge Maltz, he uses the language from the well-known jury instruction that we have concerning how you look at witnesses, the demeanor, the frankness, the intelligence, the interest, that kind of thing. To Judge Maltz, that was very important in drafting this final judgment. I have, in my 43-year career, all of the jury trials that I have, that jury instruction is always read. And for some reason, Judge Maltz found it very important that that language be a part of the final judgment.
Well, that's probably because there was quite a bit of conflicting evidence, wasn't there?
No doubt.
Yeah. But just, you know, the trial judge being able to observe credibility is only part of the story, right? Because there still has to be competent, substantial evidence to support whatever ultimate ruling is made, right?
Clearly.
And I think that's what the appeal's about, mostly.
I think so. And my problem is, while I read the final judgment, and I was the trial attorney in St. Johns County at the Watson Center, I can't disagree with Judge Maltz's findings of fact that specifically addressed each one of the torts and the conclusions of law. And so...
What about the conversion? What about the conversion claim? How is the trial judge's, how are the findings supported? I mean, it's undisputed that there was equipment, furniture, right? Things like that.
Known as...
I mean,
yes.
you know, I mean, does the record demonstrate that those things had at least some value, do you think? Or do you contend that the furniture and equipment in the restaurant had no value?
The determination that Wigg had abandoned the property before, the determination by Judge Maltz was that he had abandoned the property before the conversion. That's from the final judgment. Mm-hmm. And the finding that, so therefore Beachway and Wigg had... Let's
assume for a moment the panel doesn't agree that Mr. Wigg abandoned the property.
Okay.
Because there might be a difference between abandoning the property itself and abandoning the restaurant's operations, right?
I understand.
Okay. So let's assume for the moment that the panel decides, and I don't know if we will, but let's assume for a moment the panel decides the property itself had not been abandoned. Wouldn't that sort of imply that the furniture inside the building hadn't been abandoned by Mr. Wigg?
I guess Judge Maltz could have ruled in that fashion. He did not, and I also think that
well, he could have. The question is would competent substantial evidence support a ruling that the furniture and equipment had been abandoned? And so I'm asking you to assume for a moment that the panel decides that Mr. Wigg had not abandoned the property itself. Okay, That's different than the restaurant operations, right?
The equipment's just sitting there, yes.
Right? Inside the building, right?
Right.
But let's say the
Correct.
panel decides the evidence undisputedly shows he had not abandoned the building. Okay, so wouldn't that mean that he also hadn't abandoned the property inside the building?
Yes, it would, and isn't that what Judge Maltz ruled? He ruled that the property was abandoned. He didn't say...
No, I'm saying, wouldn't that say that he had not, Mr. Wigg had not abandoned the property inside the building?
Judge Maltz even used the term FFE, furniture, fixtures, and equipment, all right? And it's my understanding from the reading of the final judgment that basically that's what the judge was saying.
I think you're right. I think that's partly what the judge was saying, and if we find that was error, right? Now, the conversion of the equipment and the furniture, that kind of stuff, now that's back. What other grounds would we have to affirm on the conversion count, I guess is what I'm asking you.
I understand what the court is saying, that a building on itself containing property isn't necessarily abandoned just because the restaurant isn't going on, the owner doesn't come there every day.
Look, Mr. Wigg says, hey, I was trying to get the thing going again. I had a plan to get it going again. And I don't know why, I don't know why he didn't have I mean, legally speaking, if the improper eviction hadn't happened, why couldn't he have stayed and throughout, as long as he had money to just stay there and pay rent, why couldn't he stay and try to get the restaurant going again? Almost starting over, right?
Judge Maltz had 3 days to make observations about Mr. Wigg, his credibility.
I'm just saying the operations could have ceased, but the building didn't necessarily have to be abandoned just because the operations ceased, is my point.
Well, of course, Mr. Wigg doesn't own the building, of course.
I know.
We understand that.
Yeah. Mm-hmm.
Yes.
That's why he had to pay rent.
He did own the fixtures inside the building,
Yes, he
correct?
did.
Okay.
Yes, but I just wanted to make sure that you all understand that when Mr. Wigg came to that building, he didn't buy the building. That building was owned by the appellees.
If we conclude that the evidence supports a finding that the operations had been abandoned, does that necessarily mean that the lease itself, that the building itself had been abandoned? Yes or no?
If the rents had stopped, yes.
Okay. Rents issue aside, let's put that aside because that one's complicated. The trial court might have erred on that, right? Rents aside, is it possible to cease operations of the restaurant but not abandon the lease itself, not abandon the building?
Yes, as long as you're paying the rent and everything else is
And
timely.
then if they're not paying the rent, then your client should have to do it the legal way, correct? The eviction the legal way, not the wrongful way?
Yes, I would agree with that, Your Honor. Yes. Yes.
So, if operations in the hypothetical world where operations had ceased, but Mr. Wigg had not abandoned the lease or the building itself, why isn't your client liable for conversion of the property inside the building?
Because Mr. Wigg, Beachway, he's one and the same, had basically abandoned the effort for a restaurant and abandoned any profitable, anything positive other than destroying the property inside of my client's restaurant.
After the wrongful eviction, you're talking about? Yeah.
Yes. Yes. My client, the evidence that was before Judge Maltz was obviously...
Why didn't Mr. Wigg have the right? Let's assume for a moment that the restaurant had failed and that the restaurant operations effectively had ceased. Why didn't he have the right to sell the furniture and equipment inside the building that he still owned? Why didn't he have the right to sell that and sort of take whatever, to cut his losses, if you will, by selling that?
He probably could have.
Well, but okay. So why isn't your client liable in conversion?
If you remember from the chain destruction testimony, he didn't destroy the kitchen property. He destroyed part of my client's building. That's what he was destroying. And the point being was that, yes, I agree with you that he could have sold a stove. He could have sold a refrigerator. Yes. But meanwhile, he's over there doing how much damage to my clients?
Are you making like a set-off argument now?
Not so much a set-off, but the court, if you take a look at the final judgment, found no damages, on any of the torts.
Well, part of it was because the furniture was, quote, moldy or something, I guess, right? Am I remembering that correctly? There was something about mold in the record, right?
Well, there may have been. Why is furniture moldy? It's because the restaurant has ceased operation, it's ceased profitability.
It was unclear to me. I wanted to know when was the assessment made that the furniture was moldy? Because was it made at the same time that that they came in and said, well, there's $593,000 worth of damage 2 years later? Or was it on November 20th?
To be candid, I don't remember that.
Yeah.
I don't remember the testimony.
Okay.
It was 3 days worth of testimony,
Yeah.
and the fact that a chair was moldy or something like that. But
I'm just not sure how the testimony that Mr. Wigg destroyed some stuff in the restaurant after the wrongful conversion, after the wrongful eviction. I just don't know how that eliminates conversion damages for the property inside the building.
Well, then the appellants would have to have proved their damages, and that was rejected by Judge Maltz. Judge Maltz.
Because he said they had abandoned the property, but if we conclude that there's no evidence to support that finding, is there some tipsy coachman reason for us to affirm?
Say that again, Judge.
Is there some tipsy coachman basis for us to affirm if we conclude that the trial court's ruling that Mr. Wigg abandoned the property inside the building, if we conclude that that was an error, is there some other reason why we can affirm on the conversion?
Well, remember, Mr. Wigg abandoning that property may be a little different than a restaurant abandoning that property. My point being is, if you have a restaurant inside, and we've already had this discussion, where Mr. Wigg could be standing there doing nothing, so he's not abandoning it. But if you've got a restaurant and it's supposed to be profitable, it's supposed to have employees, it's supposed to be active on a daily basis, and that was abandoned. That portion of that concept of that restaurant was abandoned.
But the value of the property is still there. Just because the operations have failed, just because the profitability of the business has failed, that doesn't mean the assets are worthless.
I agree, and I would agree with that.
Okay, I'm going to ask you again. I've asked a bunch of times. Why, if we do not agree with the trial court's determination, if we say there wasn't evidence to support the determination that the property was abandoned, what other basis do we have to affirm on the conversion count?
I don't.
Tables and chairs and
If that's going to be the
stuff,
panels.
if it wasn't abandoned, if there was no evidence that it was abandoned, the physical chairs themselves, how do we affirm on the conversion count?
If that's the panel's position, then I agree with you.
Okay.
I agree with you. I'm not.
So the conversion issue turns entirely on whether or not the tables and chairs and all that stuff was actually abandoned. It doesn't turn on the operations. It has nothing to do with whether the operations were successful in November.
Well, and again, you are clearly making a strong point about that operation, or the lack of abandonment can be somebody standing in the middle of the restaurant doing nothing on a restaurant that used to be very profitable, a lot of employees, food licenses, electric, everything taken care of, where basically you are now saying that the owner, Mr. Wigg, is standing in the middle of the restaurant pointing at his stove saying it's still my stove. And I would agree with that. I would have to agree with that.
All right. I guess the point is the conversion issue comes down to whether or not there's evidence in the record to support a finding that the tables, chairs, stoves, all that stuff, that stuff was specifically abandoned or not, right?
Yes.
Okay.
Yes, it is. But in conclusion, I've got 9 seconds left. All I can say is that we place such a high burden on our circuit court judges here in Florida, and I appreciate that. And I believe Judge Malta is a very experienced judge here in Florida, did a great job with the trial, that his final judgment should be affirmed. And I thank you all very much.
Thank you, Mr. Winter. Rebuttal, Mr. George?
Thank you, Your Honor. May it please the court. I know that I have very limited time here, so I want to address some of the questions raised. The first, I do want to get into the actual numbers that were referenced for just those 3 days. November 5th, it was $2,027. November 9th, almost $5,500 worth of sales. And November 14th, $771 worth of sales. Those were just for the 3 days. Again, those were just contradicting the testimony of Ms. Kluger. If you look at the entirety of the month of November, there was almost $28,000 worth of sales. In October, there was $46,000 worth of sales. And again, November was only until the 19th of the month. It was only 2/3 of the month. If you include the entirety of the month, on an average per day, it would be roughly the same for October. Again, it's hard to say that a restaurant has been abandoned if it's doing almost $50,000 of sales each month.
Those are sales, not profits, though, right?
Those are sales, not profits. But as it relates to profits, it was undisputed, and this is the undisputed part, that there was profit for the year of 2020. Even Applee's own expert, Dr. Lowe, acknowledged that for 2020, there was a profit. And we all know the old saying, which was used during the court, you can't go broke if you're making a profit. That's what was going on here.
What was the profit?
Excuse me?
What was the profit?
It was, I think it was $20-something thousand, Your Honor, if you include everything. There was testimony that the EBITDA could be as much as $180,000, as low as $20,000. Again, with respect to unlawful eviction, the measure of damages is lost profits. What Beachway was prevented was those lost profits in the future. I do want to switch this briefly to the tortious interference and conversion claims. Tortious interference, there was a significant error in tortious interference determination because the court specifically said that the events on November 19th, 2020 constituted tortious interference. In the court's tortious interference ruling, it ignored November 19th, 2020. That's significant because in tortious interference, if the business is destroyed or prevented from going forward, the measure of damages is the value of the business on the day of the tortious interference. Much kind of like conversion, where it is the value of those assets on the day of the conversion. And clearly here, there was still FF&E, there was goodwill, there was contractual rights under a favorable lease. That business had value. To say it didn't is fundamental error. It is a severe error and overstatement of the court that does not satisfy or not supported by competent and substantial evidence. Thank you very much, Your Honor.
Thank you, Mr. George. That will conclude our first case of the OA calendar. If you'd be kind enough